So now your employer, yeah, is going to start sees that and says, all right, we're going to start, taking money out of her paycheck, okay? Or you go to sell your house, okay? Or you go to buy a house and you realize that, oh, Kyle docketed a $20,000 lien, okay, already. And you go to court and you say, hey, I didn't know about this. I had no idea he was suing me for $20,000. He didn't try to call me. He didn't tell me anything. And the court's going to say, Mr. Winey, did you serve her at her registered agent address? And you say, absolutely I did. Here's the affidavit. I didn't get it. Okay? Now how are you going to go into court and prove a negative?
Right.
How are you going to prove that you didn't get it, right? That's what a registered agent and a resident agent needs to be able to do, is to say, we have a system for documenting all our mail, all our faxes, all our private process service that comes in. We always pass it on to our clients, okay, to let them know immediately. We didn't receive anything for this client. Say say my firm was your resident agent, okay? I would say, I never received anything for Cynthia. Kyle says he served it on this date, but we have a system and we document everything that we get, and we have for, years, and we didn't get anything, so he didn't serve it. And the court will say, all right, you lose. Kyle loses, okay? But you can't do that if you don't have a system in place. So that's why the answer to number 2 is true. It is unwise to have your resident agent or your registered agent teach 2 for 2.
I took business law many years ago.
So it should not be the same as you, the owner. So our firm does this, other firms, other corporations do it as well.
So you can hire a law firm.
You can hire a law firm. You can hire a service company. I forget. There's a corporate or registered agent, Inc. I mean, there's a variety of them that do this as a business. Okay, but just to list yourself or your home address or your work address. All right, say Dawn, you listed your new place. Okay, that you've got, and you're not there. Okay, or someone else is there. You got a volunteer there just watching it for you. Right, then you don't get served. So
it just gives you that extra protection.
Yeah, it's an extra layer of protection, because that can be incredibly detrimental, right? Because once you get to the stage where Kyle's filing a garnishment, you're done. You don't have a chance to go into court because they already entered a default judgment against you. You don't get to go in there. If I were your attorney, I would try hard, but we wouldn't have much. Okay, we'd just try to fight the collections. But you're in the collection stage. You're not in the fighting stage, right? So you miss that whole chance, right? So I had to do that for a client that got served but didn't bring it to me as their attorney soon enough, right? And so there was a default judgment already on the court's docket, right? And I had to run in there and argue, please don't enter this against us. My client tried to send notice, blah blah blah. It was the client's fault. They should not have done that. But just barely we won on that, right? Otherwise it would have been $340,000 judgment against the business and the individual owner, right? Without any chance for us to say anything. Yeah. So that's incredibly important. Okay. Number 3, you can operate your business safely using any name that you choose.
False.
False. Why is it false?
You have to do a search to see if someone,
Okay.
intellectual property,
Yeah.
someone may have already registered as intellectual property.
Right. Okay.
Both the website and the corporate name.
Right. So you've got to make sure that it's distinguishable. You've also got to make sure that you register it. Okay. So in Virginia, if you're doing business using an assumed name or a fictitious name, you've got to register that name. Right. You've got to register it. Generally, best practice is to do it in each county that you're doing business in, using that name. But you at least have to register it in your home county. And if you don't do that, there's penalties involved, statutory penalties. And then if you're named in a lawsuit, or if you try to bring some sort of lawsuit, say you have an issue with a contract that you want to get out of, and you want to sue, and you want to list your name. Okay? If you get to the lawsuit, the judge is going to say, you listed this name of Dawn's Horizons, but that's not actually a corporate entity. It's not registered anywhere. You can't sue, right? So you lose. Now you can remedy that. You can fix it during the lawsuit. But yes, you have to register any name that you're using. Register in each county, and we already talked about the resident agent. Let's go to number 4. Partnerships can be safely done without any written agreement.
False.
No.
False. Good. Y'all got
That
that.
was a key word, safely.
That goes right there.
Yeah. So why would it be false?
Because people change their mind.
Yes. People change their minds. Yeah.
That's right.
We've seen many of these go south, right? So you've got people who start working together and they decide they've got a common vision, and one wants to put the money in and one wants to do the business, and they think they have an agreement and they don't put it in writing. We've got a case right now where it's they're supposed to do referrals, and one guy was the contractor and one was bringing business, and they've got some stuff written down, some stuff that's oral, and we don't have a good idea of what the agreement was, right? And so there's a demand from their attorney, we're trying to respond, and they have to get litigators involved, and it could have all been simplified if you had something in writing at the beginning. So if you're thinking about growing your business and you want to bring in partners, you want to bring in someone as an investor, you want to bring in someone as an idea partner, or have them be part of the LLC, another member or manager of the LLC. Or bring them on to, if you've got a board or something like that, get everything in writing. It's very important. One of the primary things you want to have in writing is an entry and an exit strategy. So if you have someone who says, I want to bring in money, I want to invest in the company, you got to know how they're going to come in, right? Who's going to be responsible for what? What are they bringing into the company? How are we going to get out? How are we going to end this relationship? Okay. We had people come to us with an LLC agreement. They were partners, or this was one of the partners, and you came and said, hey, I want to get this other person out, right? He's a member of the LLC, but it was 50-50. Like, okay, well, we can't do anything because you have to have unanimous consent of all the members, and you want to get one of your members out. So I can't do anything at that point, right? It's like, we can try to cut a deal with them, but the agreement says 50-50 split. So someone who had drafted that agreement hadn't thought of the exit strategy at the end. So you got to have a vision to look forward and say, okay, this relationship goes south, what are we going to do? Okay, I'm in a case right now. We got emergency injunctions going back and forth because we had potential business partners that had a falling out and things weren't in writing, and there were agreements, and so was providing this, and this was by permission, and then it was revoked, and there's just a lot of attorney's fees spent, a lot of stress. They can't be in their space operating their business, and they've got competition. So if you've got an agreement, you've got a partnership, write it down, put it in writing. That's incredibly important. How am I doing on time?
Oh, what time
You're good.
I don't want to ramble on for too long. I want to go over some stuff with contracting issues here. Let's go to number 5. A memorandum of understanding is a binding contract.
True.
Okay. Why do you say true?
Well, people do use MOUs.
Yes, they do.
They do.
Yep.
They do.
We've seen them a lot.
Yeah, you do see them a lot.
Okay. So I'll tell you, a memorandum of understanding. It depends on what's in it. So it depends how it's drafted.
Right.
Okay. But a contract has to have a couple of different elements in order to be binding on all the parties.
Okay.
Otherwise, it's just a good faith agreement. Like, oh, we're just gonna help each other out and be friends. But that's not enforceable in court.
Okay.
Alright, so generally when I see a memorandum of understanding, I see something that's not enforceable, that's not clear on the terms, doesn't have a clear definition of what each party is providing and each party is doing. It's more like an LOI, letter of intent.
It's like we're saying,
yeah,
this is what we're thinking.
yeah, we're gonna talk. We're gonna talk, and we're gonna try to work out a deal. So always be careful about what you're signing. All right, make sure that it's got.
Well, I thought that's why it was binding, because you both have to sign the MOU, right?
Well, an MOU can be binding. Usually, I like to call them memorandums of agreement and change some of the terms so it's an actual contract.
Because I thought
right?
once 2 people signed,
So it's possible
binding.
2 people can sign something and it not be binding.
So we need to know what are the 3 or 4 things that makes it a legal contract.
So yeah, that's what you pay me for.
Regardless of what.
Gotcha.
You
You thought this was gonna be everything.
gotcha.
No, so you're right, there are a couple of things that I'll tell you need to be in a contract. But the reason I answer you that way is because it's always gonna be
It's true though.
fact specific, so it's always specific to what that contract is. I couldn't give you a template
Right.
contract and say, hey, just for all your agreements, just sign this, and it'll be good. I couldn't do that.
Right.
I'd lose my bar license
It's
if I did that.
customized, right, I understand.
Yeah, so, but generally, in a contract, the court is gonna ask the question, did you have a meeting of the minds? Okay, so did this person over here think in their mind the same thing that this person over here was thinking, right? And generally, you'll see that in the contract, right? Another thing the courts will look for is clarity, definiteness. Okay? Is there a definite term? So one of the things they need to see definiteness on is price. Okay? If you say, I'm going to sell you this and we'll work out the price later, it'll be at a price that I set, right? One party sets in the future, right? There's no meeting of the minds on what the price is going to be. Okay, so when you're thinking about entering a contract, you want to have clarity on the material. They're called material terms. One of them is price. Okay, and you want to make sure that you are not thinking something different than the other parties. Right? Contract negotiation is not the time to say, we'll figure it out later. Don't do that. We have too many people come to us and they didn't think of something or they thought the deal was something else. Because once you have a signed agreement and the courts do find that it was the meeting of the minds on that, they'll enforce it. Alright? So once they get to, okay, we see that you guys both agreed on the material terms here, you signed it, they're not going to hear evidence of, well, we talked about this like a week before that, or a couple days after I called them up and said, yeah, can we do this, or let's do it differently, let's just drop the price, or why don't you deliver it to me a week earlier, or I want a different product, okay? If it's in the agreement, they're not going to look at other oral agreements around it, right? So you want to be very clear about what you have in your agreements. That goes to number 6. An oral agreement is good enough to enforce in a court of law. What is that? Is that true or false?
False.
False.
It's actually true.
Wow.
I just
Well, wait a minute, okay, hold on. How can you not enforce an MOU that is in writing and signed, and I can go to court and say, but you said, and you
Yeah,
enforce that?
because it's the meeting of the minds question. So an MOU, very often, is not a meeting of the minds on material terms.
That's why they go.
So meeting of the minds trumps whether it's written or not.
Well, if there's a written agreement, that usually will trump. That usually will trump. But if you don't have,
But a written agreement without the meeting of the minds is still weak.
it's still weak.
Right.
Yes, and an oral agreement can still be enforced, right? So if Kyle and I talk to each other and he says, hey man, my car needs washed. I want you to wash my car. And I say, okay, I'll do it for $20 next Saturday. And he says, deal. And we shake on it, okay? That can be an enforceable contract, right?
Wow.
Yeah, because we had a meeting of the minds, right? We know what the terms are. I wash his car. He pays me $20.
Telling the truth, though.
Okay, people will always lie.
Right, that's what I'm saying.
Yeah, that doesn't mean, that's why I say it's harder to enforce. It's harder to enforce an oral agreement
Right.
in court. So if you come to me and you say, Dan, I want you to sue so-and-so because we had a discussion and we agreed on this, $50,000 what I was going to pay and he was going to provide me with X, Y, Z, I'm going to tell you, yes, you have a very hard case.